My name is Daniel Kanstrom. I'm the faculty director of the Rappaport Center for Law and Public Policy here at Boston College, and also a professor at the law school. In those capacities, and on behalf of our executive director, Lissy Medvedow, and our assistant director, Abi Chingo, who's in the back, it's my pleasure to welcome you to this excellent event. I know it's going to be excellent, so I can even describe it before I hear it, because the subject is compelling and the panelists are outstanding. There are, as you probably know, precious few cases in the 200-plus year pantheon of U.S. law that are so well known and so iconically important that they are referred to by only one name. For some of these are infamous: Korematsu, Lochner, Plessy, Dred Scott, part of what some call the anti-canon. Others continue to provoke legal and political controversy, like Roe and Dobbs and Citizens United. But there are truly precious, very few cases that are almost universally acclaimed as watershed moments in the history of U.S. jurisprudence. Signposts in the evolutionary history of rights protections upon which the most positive aspects of our current legal system continue to be built. You can count them on one hand. I would say Brown, Miranda, I would add Obergefell, and the case upon which we focus today, Gideon. This was, of course, a criminal case, and in that sense it was somewhat limited in scope, though its importance was immediately apparent. As Robert F. Kennedy, Sr., not Jr., wrote in 1963, there is an important difference there, as you may have discerned. Quote, "If an obscure Florida convict named Clarence Earl Gideon had not sat down in prison with a pencil and paper to write a letter to the Supreme Court, and if the Supreme Court had not taken the trouble to look at the merits in that one crude petition among all the bundles of mail it must receive every day, the vast machinery of American law would have gone on functioning undisturbed." But Gideon did write that letter. The court did look into his case. He was retried with the help of competent defense counsel, found not guilty, and released from prison after 2 years of punishment for a crime he did not commit. And the whole course of legal history has been changed. End quote. Now that was all to the good for those charged with crimes and for the integrity of our legal system as a whole. But it left many, many major questions unanswered. Some were within criminal law. Did it apply to violations? Did it apply on appeals? What is the standard for competence? Et cetera, et cetera. But many other questions have arisen in areas of law that are sometimes called quasi-criminal and even civil. And I hedge the definition because in areas like immigration law, where I practice, if you do deportation cases, there's a very robust debate about, is deportation punishment, and if so, should it be subject to constitutional norms? In other arenas, there are similar debates going on about the stakes for the litigants and the importance of the cases for society, and the history and the nature of the government action. So these are the arenas in which our stellar panel today will engage. Where do we now stand in the continuing evolution of Gideon? It is clearly a precedent that is still yielding fruitful progeny in a diverse array of situations where people face the awesome power of government and argue for a right to counsel, sometimes successfully, sometimes not so successfully. I hope that you'll agree that there are few more important, relevant, and challenging topics to explore in a law school setting. One note before we begin: this session is being recorded. I'm required by law to mention that to you, so you now know. Let me turn things over to our capable moderator here. This is Russell Engler, a professor of law and director of clinical programs at New England Law, Boston. He directs the Public Service Project at the Center for Law and Social Responsibility. Before joining New England Law, Russell Engler was director of the Housing Law Unit for Brooklyn, New York Legal Services, clerk for the Honorable Francis D. Murnahan, Jr. of the U.S. Court of Appeals for the Fourth Circuit. He's been a lecturer on law at Harvard Law School and was the 2004 chair of the Association of American Law Schools Standing Committee on Clinical Legal Education. And perhaps most relevantly, he serves on the Massachusetts Access to Justice Commission and is a member of the steering committee for the National Coalition for a Civil Right to Counsel. So let me turn it over to him. Please welcome him and our panel to Boston College. Thank you very much.
Thank you so much, Professor Kanstrom, and welcome everyone. It is truly an honor to be here. I have 3 jobs right at the outset. I'm supposed to, in about 3 minutes, lay a further background to build on what Professor Kanstrom said. I'm supposed to give the briefest of biographical sketches of my wonderful colleagues on the panel. They deserve much more than we're going to have time for. And then the hardest job, as I turn it over to them one after another, is as they're telling us incredible things we need to hear, I have to stop them after 5 minutes each time, because what happens next is that I'm going to moderate a panel discussion, firing questions at them to answer in turn before we turn it over to all of you for questions from the audience. And as if that's not tricky enough, one thing a professor is supposed to do is to attend his own class, and I have class at 2 p.m. in downtown Boston, so I'm going to be slipping out a few minutes after 1. Other moderators will take over. Please do not interpret that as a lack of interest. I would love to continue to be here the whole time. Building on what Professor Kanstrom said, when I meet my new clinic students each semester, they're all practicing under the student practice rule, handling civil cases with indigent clients. I throw a 3-question pop quiz introduction to poverty law at them. One question has to do exposing them to the vast array of unmet civil legal needs in this country. A second focuses on housing, but is designed to show how many people are forced to appear in our courts without lawyers, and in the area of housing, it very often is a represented landlord on the other side and a lawyer and a party tenant without representation. The third question is a conversation stopper, because I say we generally know, either from law school or watching too much TV, that on the criminal side, you usually have a right to a lawyer if you're poor. That's not just Gideon, by the way. There was a whole history before Gideon and a whole landscape built afterward, but 1963 is certainly a watershed. But the question is, where, on the civil side, is there a right to counsel? Deafening, stunned silence. People haven't thought about it, people don't know, and it's understandable. It's just Gideon was such a watershed that in the 60s, as the entire criminal landscape was being built, people were starting then and there trying to achieve a civil Gideon and expand the rights to civil areas. And at the federal level, there were a few successes. In Ray Galt in 1967 established a right to counsel for juveniles. We don't always think of those as civil cases, but they are. There were a few other areas, but that strategy crashed and burned in 1981 in a case called Lassiter versus Department of Social Services. That was a termination of parental rights case. A bitterly divided Supreme Court, 5-4, said no categorical right to counsel. If we were only in a law school setting, and part of our aim here is to bring you out of just law school into the real world, we might say, well, that's because criminal is different from civil. We might say, well, that's politics of the court. It wasn't the Warren Court anymore. There were appointees from President Nixon. I actually think there's 2 other takeaways I would flag. The first is that with Lassiter, the United States chose a different path from Europe, because just 2 years before, the European Court of Human Rights had found that there was a right to counsel in many civil areas. And the other important thing, and the answer to my pop quiz question to my students, is that all of the attention shifted to the states, and other than a few federal exceptions, the answer is there's a right to counsel in the areas where there's a state constitutional right or a state statute. And in fact, most states do have a right to counsel in termination of parental rights, but it's no thanks to the Supreme Court. And in Massachusetts, for example, there are quite a few areas in which there is a right to counsel. We often think of the Committee for Public Counsel Services as the public defenders. In fact, a third of their budget is on right to counsel for civil cases, and 2 of our panelists have vast experience with CPCS. If you are looking for something, what I think of as fun to do, you can judge me as you wish. The National Coalition of the Civil Right to Counsel has an incredible feature, a status map online, where you can click on a state and see the different areas where there's a right to counsel, or you could instead pick a subject area and see which states have that right to counsel. So from 1981 on, the states got into the act with different ways in different states, And there was continued pressure to figure out where should we be expanding this right. And in 2006, the American Bar Association issued a resolution calling for the states to supply counsel to indigent in areas of safety, sustenance, child health, shelter, child custody, shelter, and health. And in later resolutions, they added physical liberty tied to immigration as well. And in response to the ABA resolution, the Boston Bar Association created what was actually a statewide task force. Studied a year where we should be focusing in Massachusetts, came up with the clever title they were very proud of, called Gideon's New Trumpet, as a report. That's a takeoff on the Anthony Lewis book, Gideon's Trumpet, which is still worth the read. And the 4 areas that that report focused on were housing, family, juvenile, and immigration. And luckily we've got an expert on each of those areas to talk to you in a second. But before I introduce them, the United States Supreme Court in 2011 dove back into this after 30 years in the case of Turner versus Rogers. Turner involved civil contempt for a failure to pay child support. Mr. Turner was threatened with jail 3 times and actually incarcerated for over a year in 3 different sessions. And it went back to the court saying, okay, this is jail, don't I get a right to counsel? But it's civil rather than criminal, and for those not into the weeds, in civil procedure you can actually sit in jail a whole lot longer under civil contempt than criminal contempt often. 9-0. The United States Supreme Court, which doesn't agree on anything, 9-0, said no categorical right to counsel. Part of the reason they thought about that was there was a 5-judge majority that said, you know, we think appointing lawyers for everyone is not what's needed here. We might feel differently if the government was on the other side. We might feel differently if Ms. Rogers had a lawyer. We think South Carolina's procedures are a mess, and that the better thing to do is to reverse the decision, send it back to South Carolina to fix its procedures so maybe we don't have to provide lawyers for everyone. And I navigate both the access to justice and civil Gideon worlds, and the spin on this, or the takeaway, is that this was a loss for civil Gideon, but a win for access to justice, which is a series of initiatives that you'll probably hear more about, trying to make the courts fairer. And so as you listen to the panelists, whom I'm going to introduce in a second, I encourage you not just to listen to doctrine and civil Gideon, but listen to the underlying problems that they're discussing in the legal system that create barriers and make it unfair, and try to help us all think about where do we really need lawyers, and where may there be other types of responses that can achieve the underlying goal without necessarily just saying all or nothing, we need lawyers. So the civil Gideon conversation really is part of the access to justice conversation. And with that, I want to introduce our incredible panelists. I've already apologized to them for giving a short version of their bios. They deserve much more. Judge Grant comes to us from Alabama. She is the presiding district judge of the Civil Division of Jefferson County, Alabama. She's going to end up speaking first because we're following the lead of Gideon's New Trumpet. She presides over civil actions, including landlord-tenant cases. She had a rich practice career before as a prosecutor, as a public defender, and in private practice with both civil and criminal cases. And she has a recent article, Civil Gideon, A Judge's Perspective on the Right to Counsel in Eviction Cases. And as you'll hear, there's been some exciting trends since about 2017 in this area. Attorney Laura Gall is the managing attorney of family law at Greater Boston Legal Services. She held a comparable position at Northeast Legal Aid and was a staff attorney at Community Legal Aid in Worcester. She has litigated cases involving civil right to counsel issues for indigent litigants, and she is a main player and an absolute star in the access to justice area, having served for 2 years as the paid consultant, having served on the executive committee, having served as the co-chair, and now presiding over the family law committee there. Judge Blitzman before he retired, was the first justice of the Massachusetts Juvenile Court in Middlesex County. We could spend the entire rest of the time, even after I leave, just talking about all of the amazing things that he has done in the juvenile area. Before he was on the bench, he co-founded at CPCS the Youth Advocacy Project. He's been on every juvenile justice task force and commission you can imagine, and has somehow managed to teach at not one but 3 different law schools along the way. So he will be talking about juvenile issues and lots more. Attorney Jennifer Klein is a nationally known speaker and expert in the area of immigration. She's the director of the Immigration Impact Unit at the Committee for Public Counsel Service. And in that area, she not only looks at the impact of criminal and juvenile delinquency charges with respect to immigration status, as well as the impact of immigration status on child welfare and family defense cases. And I will say that again, I hope I don't be heard as being dismissive of what we talk about in the law school setting, but lawyers and judges and law students, in my view, are very prone to seeing the world in stark divisions. Is it criminal or civil? Is it property? Is it contract? Is it whatever the different subject matters are in the textbook? But this whole testament, and certainly Attorney Klein's practice, reminds us all that for the users of the court and for the clients of legal aid, they don't live life in very neat doctrinal divisions the way we teach it and think about it. They just live their life and have problems. And it's for all of us, in my view, to figure out how to cut across those stark divisions and respond to what they most need. So with special thanks to Judge Grant for traveling the furthest, I'm going to let her start and then rudely shut her off after about 5 minutes.
I am Shera Grant, and as you stated, I'm one of the judges in the civil division in Birmingham, Alabama. About 65% of the cases that I handle are eviction cases. One of the things that I noticed whenever we had large eviction dockets, and a lot of the articles call them eviction mill courts, where it's huge dockets and individuals are representing themselves without an attorney, and specifically they're women, and even more specifically black women. They're representing themselves without an attorney for non-payment of rent or based on criminal activity. I found that to just be very troubling to me for something that was so important, you know, risking losing your home or homelessness. I started to really look into this issue a lot, and so while working on my LLM at Duke, I decided to start researching about the tenants' right to counsel. Because I knew in 2017, from my research, 2017, New York was the first city to provide a right to tenants facing an eviction, and then soon thereafter we had other states, other cities like Cleveland, and they put certain caveats. If you were a tenant with a child, then you would qualify for right to counsel. And then in 2022, New Orleans provided that same right. And so I was wondering, well, why can't we do that in Jefferson County in Birmingham, Alabama, which is the largest county in Alabama, because we were seeing a massive amount of evictions, and after the pandemic, things just exacerbated. So what I've been doing lately, we started a landlord-tenant committee comprised of landlords, attorneys from legal services, and other stakeholders to figure out how we can come up to provide the best route possible for our tenants. Now, this has not been an easy road in Alabama. We run on party lines, and this is not the forum for that, but I think that has been a hindrance for us because we run on party lines, and even though we have judges that think this is an issue, because they're running under a particular party affiliation, they don't want to speak on this or say anything about it. But I've recently, when Professor Engler said something about the National Coalition of Civil Right to Counsel, John Pollack is the executive director, and I spoke with him while writing my thesis, and I said, can you help us with this, whatever we can do? And he told me, if you get a meeting with the mayor, I'll provide all of the data. So hopefully what we are doing, I am meeting with the mayor. It's been several months in progress. We're trying to come up with a civil right to counsel, at least for the city of Birmingham. We're in the very early stages, and I hope that something comes out of it based on the research that we've done, John Pollack, the data that he's provided. So that's what I'm working on now, and I'd be more than happy to talk to any of you guys about it. Thank you.
Thank you, Jefferson.
Thank you. So I am delighted to speak for a few minutes about civil Gideon in family law matters, because this is an area where we have seen some significant expansion of the right to counsel, and recently some resistance to further expansion. Since we don't have time to do a case-by-case analysis, what I hope to do is introduce 3 factors that have been cited in support of establishing a right to counsel in some instances, and in rejecting a right to counsel in others. My hope is that this will help us go out into the world thinking about what are the factors that we need to be considering when strategizing about further expansion of the right to counsel. So we start in 1979, when our Supreme Judicial Court issued the decision in Department of Public Welfare versus JKB. That established that where the Department of Children and Families, then called the Department of Public Welfare, seeks to terminate parental rights and the defending parents are indigent, due process demands that the parents have access to a court-appointed attorney. In support of its decision, the SJC highlighted 3 factors. First, and most important, the significance of the interest at stake for the party seeking appointed counsel. Here, the parents have a constitutionally protected interest in the parent-child relationship. Second, the court highlighted the benefit of lawyer involvement to the court. Lawyers help bring evidence before the court, and that enables the court to make decisions with the utmost care. And then third, the court alluded to, or actually spoke directly to, the issue of fairness and the appearance of fairness. On one side of these cases, you have the Department of Children and Families representing the state and all the vast resources that the state has, and on the other, you have an indigent parent with so little resources. Since the JKB decision many decades ago, the right has expanded into cases where termination is not at stake. Only suspension of parental rights is at stake. But our courts and our legislature have still found that the interest for the parent is strong enough to warrant a categorical right to counsel. More recently, it has expanded into the realm of cases where the state is not involved, where a private person seeks to take custody away from parents. This is guardianship of minor cases, and the typical scenario is a grandparent seeking guardianship of a grandchild, alleging that the parents are either unavailable or unfit, perhaps because of a substance use disorder. Even in those cases where the state is not involved and there isn't that same imbalance of power, again, the interest in that parent-child relationship demands the due process protection of appointed counsel. More recently, there are 3 cases where the same 3 factors have been at play, but the court has rejected further expansion of the right to an attorney. The first of these 3 is guardianship of KN, in which a guardian asked for court-appointed counsel when the parents sought to terminate the guardianship. And the court said, no, there is no constitutionally protected interest in the guardian-child relationship, so due process does not demand appointment of counsel. But there was still a lot of interest in the importance of having lawyers involved so that courts get the necessary evidence to make decisions about the best interests of children. And because of that, the court articulated that trial courts can use their equity powers on a case-by-case basis to appoint counsel for guardians where they deem it appropriate, because it will be helpful to the court. Another interest that was at play here is that the leveling of the playing field, because now that parents have a right to counsel in guardianship proceedings, there is sometimes an imbalance of power if the guardians do not have access to an attorney. Okay. And then we have two what might be categorized as quasi-criminal cases. One, a defendant in a contempt of a child support case where there was the threat of incarceration or jail time in order to compel compliance with the child support order. And the other, a defendant in a abuse prevention or restraining order who in a case concerning a violation of that restraining order also was at risk of jail time. The right to counsel was rejected in both those cases, and in both those cases, what was highlighted by the court, and Russell spoke to this briefly, was that there were other procedural safeguards in place, such that due process did not demand appointment of counsel. Also at play in both of these cases was that balance of power and that perception and reality of fairness. Because in contempt cases, it is often not the state bringing the contempt, but rather the custodial parent, whose economic situation is most often either the same or far worse than that of the defendant in the contempt action. And in the similarly, in abuse prevention proceedings, plaintiffs are, in the vast majority of cases, also litigating without the benefit of an attorney. So I think that this, in wrap-up, leads us to that more expanded view of creating access to justice. The courts themselves are looking at other ways to ensure that litigants have access to justice. And for us outside of the court system, I think this is exciting because when we think about access to justice, we can include in that ways that we can reduce or even eliminate the need for litigation. And that is often a win for everyone. Turn it over.
Would I have to hit anything? Thank you. Well, I'm really excited to be here. This is an unbelievable panel and opportunity. I want to thank Dan and Russell for their incredibly eloquent introductions and framing of the conversation. I'm old enough to have been a member of that 2018 advisory committee looking at juvenile issues which were discussed in Gideon's new trumpet. And I'm pleased to say we've made some progress in those areas. The two areas that were focused on in 2008 at the time of the publication were the need for right to counsel in parole revocation hearings. This is our quaint analog to parole violations in the criminal context. This involves youth who are committed to the Department of Youth Services and more on what were known as, still are known as, euphemistically conditional releases of liberty. So there would be revocation of liberty hearings, that there was no right to counsel. Another huge issue that was targeted in the committee report back in 2008 was the need to have counsel at school suspension and exclusion hearings. Youth who do not graduate school are 5 to 8 times more likely to penetrate juvenile and criminal systems later, fueling the school-to-prison pipeline and what is known as the cradle-to-prison pipeline. At this point, I'd be remiss if I didn't make a plug for you all to take my cradle-to-prison pipeline course offered this coming spring. I do teach at 3 law schools. One of them is the cradle-to-prison pipeline course. And the reason why I mention that, it's really relevant to the issues that we're talking about today. The issues involving right to counsel that implicate significant issues of race and class. In the conversations we had, the organizational meetings, I want to share an email from my esteemed colleague, Professor Engler. Quote, "I've always thought that a true right to counsel strategy should include changes in the system that might reduce the need for lawyers in the first place. In other words, if we engage in proactive public health-oriented interventions, we will avoid unnecessary state intervention in the first instance. There'd be no reason or no need to come to court. I'll give a quick example, and this relates to a topic I want to address now, and that's the need to address the right to counsel in termination of parental rights hearings, which is the civil equivalent of a death penalty. Nationally, we spend over $33 billion in child protection. Massachusetts spends approximately $1.5 billion in terms of its DCF budget, and of that money, the vast majority is devoted to out-of-home placement in the form of foster care and congregate care. Less than a quarter, in fact, some estimates are indicate as little as 15% of the DCF budget is spent on family support and stabilization. Now, in my religion, we call that a shanda. That is not the public health model. Recently, there have been a number of initiatives to address the right to counsel in care protection proceedings that can result in termination of parental rights. Russell mentioned the sad legacy of Lassiter, in which the United States Supreme Court said there was not a constitutional right to counsel in a termination of parental rights case. Now, we live in a justice by geography world, and it's really sad, and you've got to look from state to state to see whether by state constitution, rule, or statute, basic fundamental rights and needs are being met. All too often that is not the case. We're perhaps fortunate to be in Massachusetts. From the juvenile court perspective, we have had right to counsel in technically civil proceedings, CHINS cases, now known as child requiring assistance cases, care and protection cases by rule and statute. The Committee for Public Counsel Services has recently been able to, in the last 10 years or so, has been able to assure that court-appointed counsel who represent attorneys other than their salaried attorneys, who represent juveniles in delinquency proceedings, will be reimbursed for representing students in related disciplinary procedures. So in other words, if the underlying appointment that an attorney receives is directly related to a delinquency or youthful offender allegation, they will be reimbursed for that type of representation. We've developed educational nonprofit programs to address school advocacy. Through CPCS has created the Ed Law Project. Greater Boston Legal Assistance has a school to prison pipeline project, and a number of other initiatives. As regards the care protection realm, there are efforts to create pre-petition filing representation to avoid cases actually coming to court. GBLS has a family preservation project. Attorneys such as Deb and Chris Freitas are engaged in other diversionary efforts. Let me close by saying this. I realize, as is usually the case, my time is up. But I must say this. MLK, and I got this actually from one of my students last year in my Gravelly Prison Pipeline course, reminded me in one of his papers that MLK popularized the phrase, the arc of the moral universe is long, but it bends towards justice. But it doesn't happen by itself. It takes sweat equity, it takes effort to keep pushing that rock of equity to address some of these searing inequities. And I'd also be remiss in this context in noting that while it's great to be here talking about Civil Gideon, last year was Gideon's 63rd anniversary, criminal Gideon. And I attended several colloquia, including a national ABA webinar decrying the fact that criminal Gideon has not been, the promise of criminal Gideon has not been realized. And those of us who practice criminal law are very familiar with the national crisis regarding the status of indigent criminal defense in both the juvenile and the criminal context. And finally, and thank you for mentioning Galt, Dan. Galt technically did not incorporate all of the due process rights via the 14th Amendment into state criminal proceedings. So all juvenile cases are, including delinquency cases, are technically quasi-criminal. That has implications when we have budget shortfalls as occurred in 2008 and court sessions have to be closed down. Juvenile sessions were closed across the country. So we've got a lot of work to be done. I'm very excited to be part of this discussion and panel because we have to keep pushing that rock. Thank you.
Thank you, Judge Blitzman. Jennifer.
Sure. It is always hard to be the last after three incredible advocates, but I will do my best. So just a little background about what I do in the immigration unit. So I'm within the public defender's office, and we really do, as Russell said, bridge the world between criminal and civil law. So in 2010, the Supreme Court, in a case called Padilla versus Kentucky, said that defense attorneys have a Sixth Amendment duty to advise their criminal clients of the immigration consequences of their conviction. So that's all criminal law. But defense attorneys are not immigration attorneys, and immigration law, for anyone who hasn't taken it, is a huge body of its own that is very complicated. And so the Immigration Impact Unit was born to advise defense counsel. We work with all CPCS immigrant clients. On the criminal side, the goal is to help them understand what the consequences might be, mitigate them when we can, and make sure that they are making informed decisions about the choices they're making, whether to plea or go to trial. The work is much broader than that, but that is sort of the basis of our existence. And just so that you understand, anyone who is not a U.S. citizen is at risk of deportation based on criminal convictions. It's always on an individual basis what that analysis is. You can't say that any non-citizen will be deported or subject, but everyone has the possibility. So that means even long-term green card holders, people who have lived here for decades lawfully, even minor convictions can make them deportable. People who are currently undocumented might have a pathway to lawful status, and that pathway could be barred by even minor criminal convictions. People who have asylum claims and fear of persecution can be sent back to their countries of origin based on criminal convictions. So that's the work that we are doing with defense counsel. One of the most frustrating pieces of the work is that once our clients leave the criminal legal system, there is no right to counsel in immigration proceedings. So we can do all the beautiful work of crafting dispositions and thinking about what the legal arguments are for why the conviction that they have doesn't make them deportable, but then they get sent off into the world and they end up in immigration court and no one is there to make that argument for them. Immigration proceedings are civil in nature. You wouldn't know that if you ever walked into an immigration court. It is a judge sitting on a bench in a black robe, just like any court you've ever seen. There's a trained immigration prosecutor on the other side, and you have the immigrant who is being charged with deportability, and they are not entitled to counsel. The former head of the Immigration Judges Union once said it was akin to trying murder cases in traffic court. People's lives are really on the line in many of these cases. Many people have limited education, English is not their first language, and they are still expected to make incredibly complicated legal arguments about why they should be able to remain in the country. In addition, and part of the work that I do is that the federal government prioritizes enforcement and deportation of people with criminal records. And so this is where we can talk a little bit about the way the systems interact in access to justice. The same individuals who are over-policed and over-represented in the criminal legal system are the same people who are over-represented in the immigration system. On any given day, there are 35,000 people held in immigration detention. Yeah, I forgot to mention that part. People in removal proceedings can be held in detention, even though it is civil. Over the course of any given year, hundreds of thousands of people pass through immigration detention for varying lengths of time. Sometimes it can be weeks, sometimes it can be years. 70% of detained individuals nationally are unrepresented. 60% of deportation cases overall, so meaning people who are also undetained, are unrepresented. In a 2016 article, the data shows that only 2% of immigrants without counsel were able to win their cases. So of that 70%, only 2% of them are going to have success in immigration court. Given all of that, in the last 10 years, there has been a growth in the movement for immigration representation. New York was the leader in this movement. In 2013, they began with the New York Immigrant Family Unity Project. Okay, 1 minute. It started with a very small $500,000 grant from the City Council, and has now grown into a fully funded universal representation program for everybody who is in immigration detention in New York State. It's tens of millions of dollars at this point. Other counties and states have gotten into the act and have started publicly funding immigration representation. There are some that are fully publicly funded, some are private-public partnerships. We can talk more about what they look like. They're often small and individual. There's not another statewide process. The one thing I will note is that the federal government actually by statute prohibits federal funding of representation in immigration court. So right now it is left entirely to the states and local jurisdictions to decide whether or not they want to fund it. And Massachusetts actually is very behind in this world. We have no public funding for immigration representation in Massachusetts. We have a very robust legal aid community in Massachusetts. I would not want to denigrate them, but most of them are not doing any removal defense, meaning immigration court work. And if they are almost certainly not doing work for detained individuals. So we have a long way to go in Massachusetts on right to counsel in immigration proceedings. Similarly, and I will leave it at this, I think there is a question of whether we want to just give everybody lawyers or we want to reform our immigration system. And we should be asking the questions about why our criminal system and our immigration system are linked. And I'm sure it is no surprise to anyone that our immigration system is pretty broken at the moment. And that we are also a long way from immigration reform. But that really, if we could ever get something done, that would go a long way to actual justice as opposed to just providing lawyers for a broken system.
I second that in
So the only reason I don't feel really bad about cutting them all off is that they get more chances to talk, because there's two more parts of this session. The first is that I'm going to ask 4 questions of the panelists. I'll invite each of them to answer if they wish. I'll try to hold them to a minute or two. Good luck. But then in the last part, you get to ask questions. And sadly, I will have slipped out by then, hopefully not face planting and disrupting the entire session. But Judge Blitzman is going to have taken over by then. So the panelists don't get to complain about the questions because I cobbled them together from questions they proposed, so they should be familiar to them. But the first question is, since we aren't going to get, and perhaps shouldn't even want, that's the topic of discussion, a true civil Gideon where we get full representation in all key areas, how do we prioritize? Do we pick subject areas by importance? Do we pick the litigants by vulnerability? Or what about areas where data matters? The housing expansion of a right to counsel has been heavily driven by data comparable to what Jen actually just talked about, how people who are without counsel don't have a chance in most settings. So does the data matter? So I'm going to offer it to the 4 of you to take that any way you want. How do we prioritize? And you can push back and say we should have a full civic Gideon in all instances, except I don't think there's anybody who takes that position. So
I'd like just to begin. Sure, data is important, but I want to just return to a point that I tried to make in the latter part of my remarks, and that is the need to look at this issue systemically. If we minimize or try to reduce data intervention by changing how we support children and families, we're going to go a long way. So if you look at the issue, one of the sad realities is that the average lifespan of people living in Roxbury according to a 2016 Boston University health study, is 59 years of age. This is contrasted by an average lifespan of 92 in Back Bay. That's an obscenity. We're talking about several miles. And that type of geographical segregation drives educational segregation. It drives virtually issues in every one of the categories we're talking about. DCF, our Child Protection Agency, again, spends 85% of its budget on allegations of neglect. 85% of the cases we see nationally in juvenile courts and dependency cases, as they're called across the country, do not involve inflicted allegations of abuse. So, my sort of framing suggestion is to think about these issues as regards the intersection of class and race, and to really walk the public health walk. We save money in the long run by investing in families in the short run. And I think what you need is a political commitment to reallocate. It's not a question of just throwing money after a problem. It's how do we allocate limited dollars in a way which is more public health oriented.
Thank you, Ted.
So for me, I come from a pretty practical background, having been a prosecutor where I worked in Atlanta with some really, really, really great public defenders who were making sure that their clients knew about the immigration issues. I switched to Alabama, became a public defender where I helped to set up a public defender system because Jefferson County in Alabama didn't even have a public defender system until 2013. And so I helped to set that up. So I believe in Gideon, I do. And and from seeing it in the courtroom, in the civil arena, I'm a proponent of civil Gideon. 90% of tenants are not represented, while 90% of the landlords are represented. We can see that it does save money when we present attorneys in the beginning. New York in 2017, for $2,500 that it will cost to hire an attorney, the city was saving tens of thousands of dollars for homeless shelters, emergency room visits, children moving from different schools. We save money. The outcomes are so different on a daily basis when Legal Services of Alabama, which I told her I absolutely love, when they represent a tenant, they're able to bring counterclaims, they're able to bring valid jurisdictional issues, which are similar to our motion to suppress, which would make those cases dispositive on a jurisdictional issue. Even when there is no defense, our lawyers are able to work out a better negotiation or a settlement. In Alabama, if you are evicted, you have 7 days to vacate the property. If not, then the sheriff can come at any time to throw your things out. And I don't know if you've ever seen a set out, but it looks horrendous. And they just send people in there off the street and they set it out. Well, when an attorney is involved, the attorney can negotiate with the landlord's attorney and say, hey, can you give them 30 days? They'll be out within 30 days. Those are things that when pro se tenants go into the back and speak with the landlord's tenant, they're not getting those types of negotiations. Public housing presents a whole nother issue. A lot of our underrepresented clients, the tenants don't understand that if they agree to a consent judgment on an eviction case and they live in public housing, then their benefits are lost for 6 or 7 years. And they don't know that. They don't understand on the quasi-criminal side if one of their children, if they act out, if they engage into a fight, they risk being evicted. They don't understand all of their rights. So I'm a very big proponent. I know that Gideon is broken, but what I've seen, it's the best thing that we've got from my vantage point on the bench.
Thank you, Judge Grant. Laura and Jim?
I think I would just say it feels like a both-and question. The four of us could duke it out over whose clients need the most representation. But I think the answer is we need to solve the systemic problems. And if we solve the systemic problems, there's actually no reason why, as a society, we couldn't afford attorneys for all of our cases and all of our situations, because we wouldn't need as many attorneys. And until then, we do need someone standing up in the courtroom and advocating for people's rights. And so my feeling is we need to keep pushing for that universal Gideon, and at the same time, figuring out how to solve the problems that lead to the need for so many lawyers in court.
That was beautifully put. I don't think I need to add. Really was.
So it actually almost eliminates the need to talk about the second question, because the alternative, but I think Judge Blitzman framed it in a way that had us covering both questions. What are the other responses if we don't think we can get lawyers for everyone? And make no mistake about it, on the criminal side, there are all kinds of problems with how underfunded the delivery system is. In the right to counsel, that is, I hope, a movement expanding in eviction cases, now 5 states, 17 cities, and 1 county. One of the big problems they're having is the pipeline. Where can they find the lawyers to actually do the work, and how do we avoid having them burn out? And I think the larger frame, and this is where I really just echo what the panelists said, is that let's face it, these are enormous societal problems that weren't created by the legal system. They're occurring outside the legal system, but they're showing up in the legal system.
Okay.
Hold on. Apparently I said something wrong, but before he corrects me, I want to echo what Judge Grant said, which is if we're going to have these eviction cases showing up in the courthouse, we have the balanced scales of justice. We have to provide a level playing field, and we have to give the help they need. And yet, I would rather also solve the problems outside. Put a gun to my head, please don't. I prefer a right to affordable housing over a right to counsel in eviction cases, but that's not the world we live in. So I apologize in advance for whatever I said wrong. Judge,
No,
please correct.
it's a very, very minor modification, because I'll channel, the great Smokey Robinson. I second your motions about the importance of the civil Gideon and the right to counsel. But getting back to the systemic issue, the quibble or the nitpick would be the legal system has, to a degree, embedded the problem by buying into this mythology that we live in a world of de facto segregation, and therefore sort of systemic changes around the margins. And by that I mean is, unless we have a national reckoning that we live in a world of de jure segregation, there really is no functional difference between de facto and de jure segregation. But I think those of us who live in the real world and practice in these arenas know. And this has been written about by American Apartheid, the Denton Massey book that came out in 1994. Maybe my favorite book, Richard Rothstein, The Color of Law, Forgotten Story of how the government segregated America, or a secret story how the government segregated America, document that as we sit here today, we live in a world where there are race-conscious affirmative policies keeping us apart. And these divides are incredibly consequential. They relate to where public housing is situated. They relate to the rates of COVID susceptibility. In 2020, in the heights of the early days of the COVID epidemic, was it surprising that 70% of the COVID deaths were involved African Americans living in communities like Baltimore, Detroit, Milwaukee? It shouldn't have been shocking. So that's part of the systemic, reality. And really thinking, really thinking about that. The Color of Law by Richard Rothstein, I recommend it to everybody in the room. If you take the Great Prison Pipeline, you'll have to read it. But the book begins with this whole discussion, and Rothstein's not a lawyer. Well, Rothstein is a housing specialist and sociologist. It talks about, this mythology, de facto versus de jure, and talks strategically about ways to address zoning policies, single-family dwellings. There's a whole litany of things we can do, and that's why being a lawyer at this time is critical, because I agree with you, ultimately, that we could say the problem is so vast that we can't take action, and I don't mean to suggest that. I think we need to act in courtrooms and out of courtrooms to frame these issues systemically and really understand the need for change to scale reform and what the stakes are.
Well, I appreciate the friendly amendment to my comments, but I have to say that I agree with all of this. I think Jen is right, this is both and I've worked with Laura on civil Gideon briefs, but we've worked most closely on access to justice, and I think a lot of the point there is, yeah, the mess stands in the laps of the courts, but the courts don't get to just stand back and throw their hands up and say what we can do. There are specific things that are embedded in the court's operation that have to be fixed, and there are things that have to be fixed outside the system. And so I want to get to the third question, although Laura, when you answer the third question, work in whatever you wanted to say, because we are talking about other ways of dealing with this. But what are the barriers to change that have hindered right to counsel or civil Gideon in your area? And what is the best strategy for moving forward? And that includes, if you want to push things outside the actual representation, say whatever you want, but Laura, why don't you go first, and then others can weigh in.
Sure. I think a significant barrier in the context of family law is that you have you have two sides of the V that are equally likely to be with or without an attorney, or perhaps not equally likely, but likely enough. And that is very different from the housing court context, for example. I think that with that in mind, there has been a lot of positive energy in helping people to find quicker exits from the litigation track, various forms of alternative dispute intervention, as it is called by the court. And there have been a number of programs that have come up, many of them court-sponsored, and I think that that is very important because protracted litigation is not good for anyone. The ripple effects in terms of monetary costs of just coming to court over and over again, and then emotional costs are very high. A note of caution is that I feel as though the focus is on getting to yes and not getting to understanding of the rights under the law before we approach getting to yes. And if we don't have if the parties don't have an understanding of what their legal rights are, they may be reaching a compromise that is very different from what justice would give them. I think many people reach compromises that are not what justice would give them under the law every day. And if you're doing that in a knowing way, then you're doing what's best for you and for your family. If you're doing that in a vacuum, that's two tiers of justice, and that's another reckoning that we will have.
Jen, do you want to go next? I think you've had the least amount of airtime,
Oh.
so would you like to?
Well, thank you. Though I will sort of go back for a second to the second question, but then talk about barriers. But I think this might be a controversial perspective, but we do within the immigration field have a number of programs where people are provided sort of pro se manuals or given, it's not even a lawyer for a day, it's like there's a lawyer around who can answer some basic questions. And on the one hand, it's better than nothing, and I find it incredibly frustrating because we are putting a lot of money into putting a very, very small Band-Aid on something much larger, and it doesn't actually provide clients with an ability to make a legal argument, as Laura said, sort of understand the bigger picture. What are they even entitled to? How can they make that argument? So I struggle a little bit with some of these court-sponsored or minor fixes. In terms of barriers, I just feel like we've all been watching the news for the last 10 years or so. Immigration reform is just such a hot button issue. Anti-immigrant sentiment in this country is massive. It's going to take a really big change to do anything on immigration. And so I think Congress and political opinion and whatever underlying stuff there is here in our country is the biggest barrier. And then I think it's really hard for states to understand why they should be fitting the bill for a federal proceeding. Immigration court, immigration proceedings are federal. And so it takes a lot of work to convince local communities that they should be paying for it. There are strong arguments about the economic benefits to communities of not removing primary earners and not taking kids away from their parents and then having to have them in foster care and all of the ancillary pieces that come from deporting individuals from our country, but that takes a lot of vision.
Jen, correct me if I'm wrong, but when 10 years ago when Democrats and Republicans actually occasionally talked to one another in the Senate, the bill coming out of the Senate with the Gang of Four had a right to counsel in certain immigration cases.
Yes, there was some movement towards right to counsel, not a particularly broad one if I could,
Optimus.
but
Optimus.
yes.
So I'd like to get back to an issue you raised, Russell, and that's data. So this is an invaluable advocacy tool. And I cite as an example a really important study done by Dan Lowson and his colleagues at UCLA Civil Rights Remedy Project, looking at the intersection of disability and race, really documenting the incredibly high rates at which black and brown children, and particularly children with disabilities, were being subjected to zero tolerance, school policing, being arrested, students being arrested in school as a way for school districts to avoid educational entitlements and 504 accommodation plans. So bringing that data, which shows searing systemic racism, sometimes it's hard to ignore, although, I guess here's the cynic in me. We have a lot of data not already documenting these profound disparities, which brings me back to the points I'm attempting to make. Well, yes, continuing to battle in every courtroom and pushing the envelope, client-directed advocacy, showing the consequences and the cost of pushing children and families into our system to state of prevention. There's a need to frame these issues in a broader context. One doesn't preclude the other. And so the work is really, really important, and I think that's why we're all here.
Judge Grant?
One of the things that we have done in Alabama, another judge and I started an eviction court with some of the third-year law students, which is very helpful and I think is beneficial and informative for law school students to get some hands-on training with tenants who are not represented. And then we also have a mediation program, and some of the mediators are not attorneys. They're trained in mediation to help resolve the peaceful resolution, and then we have a lawyer. Birmingham doesn't have a lawyer for a day, but some other courts in Alabama have a lawyer for a day. Those are great, but they're not right to counsel. Because there isn't a lot of data on the true outcomes of those programs, and I don't know about you, but someone showing up 5 minutes before I come to court to help me figure out whether or not I'm going to be evicted or homeless, I don't think they will get to see the full picture in just that 30 minutes before the judge comes out on the bench. The mediators, the problems are they are resolving the case, but it may not be in the best interest of the tenants. And so John Pollock and I have had discussions about that, and he's absolutely against that, which is why we're continuing to push for right to counsel here. But those programs, a little bit helps, but they are not right to counsel, and I don't think that they are beneficial for tenants in the long run.
So I'm going to ask our last question of the panelists. I'm going to then take the privilege of the outgoing chair and answer it first before I slip out and ask the panelists to one after another answer before Judge Blitzman takes over taking your questions. This is an appropriate question, I think, for this setting. What is the role of law schools and law students in this situation? And apart from noting the irony that a good thing for law professors to do is to get to their class on time, so that's an important sort of small thing, I want to say, as a diehard critic of standard legal education who believes there should be much more practical training and much less going on just in the classroom, part of the answer is more clinics, but that's, I think, also not a reality inside law schools. How do we pick which clinics? There are all kinds of budgetary things pressing against that. So I think it's already too late if that's all we're focusing on. I think this has to start from the beginning of law school. I think it's all about the first-year courses. Talk to your doctrinal professors and see whether there are ways in which they can integrate into the first-year courses any of these issues. I'm about to go teach housing law to my public interest law students. One of the things I asked them to think about was which of your first-year courses relate to the topic of housing law, and I already gave them the answer. It's all of them. The question is whether they can figure that out, and you can append exercises in the first year class You can have first-year pro bono courses. You can have expanded summer fellowships. It's too late if you just give it to the slice of people who think to take clinics. People don't realize how important this work is. People don't realize how fulfilling it can be, although frustrating. And I think it's all hands on deck. So if I've started a revolution at BC, I apologize to the BC professors here. It should please spill over into my law school as well, which could do a whole lot more. So I don't know who wants to go next, and then I will slow down.
I'll do the BC thing.
Okay, you got it.
So this is my BCQ, one of the schools again that I teach is here, and I just want to say, this is my plug for clinical education and law school involvement. You know, so when I sat in your seats, I'll be candid. By the time I was a third-year student, I was in the twilight of an exceedingly mediocre legal career. And I really didn't know why I wanted to be an attorney. It wasn't until my clinical involvement when I was representing a young woman in the Boston Juvenile Court, lied about her age. She said she was 17, which in that era would have made her an adult. Turns out she was a juvenile, and she was literally brought by her ear into the bowels of the old Suffolk County Courthouse, where she was involved with every type of proceeding you could imagine. Abuse and neglect, she was a runaway, she was being sexually trafficked, and I was assigned to represent her. My lawyer for committee supervising attorney had neglected to come with me. He told me, Jay, you can't screw this up. This is an arraignment, first-time prostitution arraignment, she'll be released and off you'll go. Well, it turned out that for me to effectively represent her, I had to learn an awful lot about a lot of other things. Educational, mental health law. This woman had a history of suicidal ideation, a long history of trauma, domestic violence, abuse, living by herself on the streets. My heart never left that case in that court, and really has informed everything that I've been trying to talk about with you all today. Later, when I started the Rochester Youth Advocacy Project, we were committed to multidisciplinary representations. You can't categorize or silo any of these issues. These issues, we see the same kids and the same families in juvenile justice and care and protection and child protection. So understanding these issues holistically, trying to engage in client-directed advocacy, trying to give voice to each client to vigorously defend them on a case-by-case basis, while also arguing in forums like this, outside of the courtroom, to create more conducive environments and atmospheres and change a culture so that the importance of these issues will actually be considered, are all things that I really quite candidly learned at Boston College Law School, or it began at Boston College Law School. So did I justify being invited to the panel?
Yeah, the check's in the bank.
I have two concrete ideas. The first is being piloted at Northeastern Law School, and that is a partnership with the Access to Justice Commission and first-year program there, where students are sent out with no information. Half are fathers trying to establish their legal relationship with their children, and the other half are mothers trying to get some child support from the fathers. And they just have to try to go to court and file a complaint. After they go through that process, they then come back and have an educational session on what the various resources are and what the law is, etc. And then they go and try to do it again. And then they pick out a project within their experience to pursue further in the second half of the year. I love the idea of law students understanding that the majority of litigants in many of these courses, at many of these courts, do not have what you all are getting. They don't have a law degree. So understanding that at the outset, I think, is important. And then the other is pretty pie in the sky, but not impossible. I would love to see alumni partner with law students just for a day. If you work in an area of poverty law, invite a 1L to come with you to court for a day to see what it's like. And if you don't, volunteer for one day of Lawyer for the Day and do it with a law student. So the law student can learn from you and you can help, 20 people, 30 people, 50 people in one day. I think if there were more of that, more of us would care enough to make some of the change that we're all talking about.
Thank you. So I feel like the role of law school for law students, and even all of us up here, if I can just be personal, is to really think about your passion and why are you here? Why are you in these seats? I have a twin sister who also is a judge, and we talk about this all. She's a criminal court judge and a civil court judge, and we talk about this all of the time. This is not for wusses. This is not for wuss. We have to step up to the plate and make it happen. I understand there's burnout, but if you're making a lot of money, you wouldn't even think about burnout, so forget about the burnout thing. Why are you here? And I remember when this sounds very cliche-ish, but my sister and I, my mom asked us all the time. Our father died when we were 5, and my mom remarried, and my mom said, what are you going to do for your community? What are you going to do? And whatever that is, she's like, you just need to ask that question and have a good answer. What are you doing for your community? So my mom was savagely beaten by her husband, who was my stepfather, when I was 10. And I've known since I was 10 that I was going to be a lawyer to right the wrongs and speak for people who could not speak for themselves, because my mother could not speak for herself at that time. She wasn't the one to call the police, because that's what other people did. We didn't call the police. And so you have to ask yourself while you're seated here, what is my passion? What am I going to do to make the world better for other people? And there's no time for wusses. And that's just it.
I'm going to let Judge Grant leave it there.
All right, we're about to open it up. I actually had wanted to just put one footnote on something that Jen said earlier about the both and thing, and I think the last round of comments have intimated to this. The connection among these issues is also poignantly clear in the connection between what happens to people who don't have counsel. So if the parent in a family gets deported, the children are left without a parent. The children often then end up in the juvenile justice system. Or if an elderly parent has an adult child who's supporting them, and then that person gets deported, the elderly parent may end up in public housing and then get evicted. So these things are all deeply connected, and the effects of not having counsel just resonate throughout the society. So I just wanted to echo the importance of highlighting the holistic nature of this and the need for policy. I was also remembering when we used to do these Know Your Rights presentations, we used to call them Know Your Rights presentations, and then among the lawyers we would say in parentheses, except you basically don't have any. So it was always a challenge to figure out what rights we were telling people that they needed to know. Anyway, let's open it up for questions to our panel. First question gets free food.
No, you need the mic.
Oh, okay. Hi. I'm kind of grappling with this, and I think the question is not the right to attorney, but just the importance of an attorney. And I'm a 1L taking civil procedure, so I can understand why you need an attorney for this. But I'm wondering if maybe is it just possible to sort of take care of this with like community orgs, and they do sort of like the legal education, and they have more accesses or knowledge of like the resources available in an organization or in a certain community, whereas attorney might better know the legal aspects of the case, but not necessarily connect them to the right people, the right resources they're after, whatever happens to the case. Can we just put more people in front of the court instead of saying we gotta get everybody an attorney?
Well, I think yes. You know, as we're talking about diversion and directing people towards appropriate community resources and support to avoid the need for going to court, but once they're in court, we've got to deal with that reality. So attorneys have to or should engage in holistic representation. Attorneys should have access to staff, if they don't have that knowledge themselves, how to direct a client towards an important community-based resource. So it's not a question of either or. It's a question of sort of changing the legal culture to make us more engaged. It's what Brian Stevenson calls getting proximate, right? You know, so I'm sure many of you have read Just Mercy. It's a question of really understanding contextually your clients and really helping them and being their champion.
The other panelists want to weigh in on that one?
I thought that was a terrific question, and I think thinking about this holistically already as a 1L is fantastic.
very sophisticated.
Well, so much of that does relate to your point, Laura, about sometimes you have the assisting where you have people who are helping in the courts, but that tends to result in a devolution to mediation. So every tenant in housing court is basically going to agree that this is legitimate, that we have to make a deal, and it's certainly better to make a deal than not to have a deal. But it would be, if a lawyer were in there, you might say, why is this legitimate in the first place? What is this eviction really about? Is there a challenge here that we could be making?
Just really quickly, in the context of juvenile, procedure, having some legal guidance or expertise in how to push cases back into schools before kids are excluded, maybe engaging in a restorative justice type of model that's where you can take responsibility and heal community without becoming overly retributive. I worked on creating a diversionary school restorative justice model for that very reason. So that's something that I think is worth considering as well.
Also, it occurs to me that Judge Blitzman referenced a relatively new project that's being tried out at Greater Boston Legal Services and also at a number of other legal services agencies across the state, the Family Preservation Project, to help families that are DCF involved, but where DCF has not taken custody of the children. And those teams are exactly that. They're teams. There's a lawyer, there's a social worker, or somebody with a social work degree, and a parent advocate. And the hope is that by holistically treating with people with lived experience, with people with deep roots in the community and knowledge of the community resources and legal expertise, that with that combination, you can really help a family move forward and avoid the need for that litigation.
Other questions? Lizzie?
Hi everyone, thank you for coming. So obviously I'm a law student, so I believe and buy into the standardization of legal practice, but I imagine that has to do with a lot of the gatekeeping of the legal profession that probably contributes to the need for civil Gideon. So in other words, if people had more access to legal knowledge, would they be able to represent themselves more? Do you believe that reducing the gatekeeping of the legal profession could reduce the need for civil Gideon or create better representation, and how do you think that we could achieve that?
Are you talking about people who represent themselves?
Non-legal advocates.
Or non-legal advocates?
Either or.
Well, I'm all for non-legal advocates prior to any court involvement, but the reason for the need for diversion, pre-arraignment or pre-petition filing diversion, depending on the court context, is that once a petition is filed, the ramifications, the consequences are so enormous. Collateral consequences, even if a juvenile case gets dismissed. Michelle Alexander writes about that in the new Jim Crow. You have a record which will stay with you forever. People think we have sealing and expungement. Your records disappear at 18. That's mythology. You could jeopardize public housing. You have a whole family on the street. So, the legal systems are so Byzantine and so complicated. Dan talked to me about consequences of what happens in somebody who's unrepresented. You could have a juvenile court judge who takes custody away from a parent, and that who is overly punitive in a case because the kid isn't going to school, and removes custody, and that might end up in that child entering the juvenile criminal justice system. I mean, part of the problem here is that we've got to change the narrative. Our narrative tends to be reactive and retributive. We want to get on the front foot with civil Gideon and the right to counsel by really educating everybody about what equity should really be all about, people access to justice.
Jen, did you want to weigh in on that?
I think because I was trained well, I'm going to dispute your premise a little bit and say that it's not that we should be training everybody to have legal education, because I agree with Judge Blitzman. It is so complicated, and there is a reason that we spend all of this time learning it. I've been practicing for 15 years, and I feel like I'm just scratching the surface of deep knowledge. But I think it's how we understand what our job is as lawyers. We are not the saviors. We are not the only voice in the courtroom. We should use our education and our knowledge to allow our clients to make the choices that they want to make, to help them understand the proceedings, and to let them inform the way in which the case is going to move forward. And so we should be educating, and we should be expanding who has that knowledge, but it just in a different way than expecting that someone who has never been a lawyer, who's never practiced, is going to have the same skills, because that's all it is, it's skills that we have all gained through our practice.
Can I just take this a little further? One of the things that I've tried to do in my courtroom and some of the other judges is have a little pro se form to help them if they can't afford an attorney. And most of the time, you know, if you can't afford to pay your rent, you certainly can't afford to have an attorney. And so that's 90% of the people that are coming through. And so I've tried to really make all of our forms very easy to understand without a lot of the legal jargon. I've tried to really, even, you know, from down to this is where your court date will be, this is what you will need to do. And I was so happy because I had about 20 different forms, but then we have those that cannot read. And so that's the issue we have. And then we have those that have signed lease agreements, and then once they are set out, they're garnished because of the back rent. There's pre-judgment interest that has been attached, post-judgment interest that has been attached. They're garnished. They are filing a motion to stop the wage garnishment, but in the little bit of that lease agreement, there's a waiver of exemptions that they didn't pay attention to, and so the only way they can stop being garnished is by filing bankruptcy. And so those are the issues that they are trying to navigate, and it's only so much that my form, my pro se form can do to help, and we're back at square one because they didn't know how to read and they don't understand that with waiver of legal exemptions.
Also, I mean, another example of that, the need for structural change is that in deportation cases, the data are absolutely clear that the difference in success between the unrepresented and the represented is stark. It's off the charts different. So you would really have to change the whole system in order to not need lawyers in a system like that.
Time for one last question.
A lot of pressure. Okay, thank you so much. I was wondering if you could elaborate a little bit more. You mentioned how an easy fix to the solution is getting more access to representation in courts, and that's easy to do with our law degrees. But I'm wondering if you could talk a little bit more about how we're uniquely equipped to handle the roots of these issues, like the social determinants of health that are making these inequities happen with a law degree, as opposed to like a master's in public health or another type of work.
Yes, I just real quickly, I'm on the advisory board. One of the schools, another school I teach at is Northeastern. I'm on the advisory board, which we're going to change the name from the social determinants of health to the social drivers of health, but you know, get hung up in language. So part of what a lawyer does is trying to bring that information into the courtroom, because a lot of, you know, if you go back historically, if you mention any of these issues in courts, if you mention race, any issue such as race, you'd be shot down to talk about the causes of things if you were an attorney. So trying to create broader legal education, and legal education is part of what the Sal's Populous Project at Northeastern is trying to do, this very thing, trying to talk about the social drivers of health so that there's a general database and we educate each other more generally, so that when judges hear cases and lawyers argue, there's a context, there's a social context to understand the larger frames and systems that affect all of us.
I also think that if your destiny is not to be a litigator, that there are lots of ways that a law degree can be used to great effect outside of a courthouse. Certainly in the legislatures, we need people who understand the ripple effects of how laws are written, and we need, I think lawyers are skilled in organizing and presenting facts and arguments, And that skill set can be used wonderfully to change the hearts and minds of those around us. So I think that you can take that skill set and use it in any number of ways to help with some of these broad systemic issues. Thank you to so many people who took time out of your day to participate in this conversation. I have to say that it's really heartening to have had such a full room and such interesting questions spoken back to us.
The questions were great. Thank you, guys.
All right, so we're going to end now. I just wanted to say this is your Rappaport Center for Law and Public Policy here at BC Law School. Get engaged. Go to our website. Next week, we have a program also on Tuesday, also at 12 p.m. on a relatively esoteric small subject, preserving democracy. So please show up for that one too, because that could become pretty important. And let me just thank this is a fantastic panel. Really, really great. Thank you so much.
Thank you.